Hello, it's Philip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a book in the beginner series from Routledge. This is for people who are new to areas of substantive law, and this one's on evidence. Evidence is not the easiest subject by any means to understand. May look easy superficially, but it isn't. And I've been teaching it now for something like 25 years, so I'm well aware of the pitfalls that you can have. Let me start off with this book anyway. It's called Beginning Evidence. It's been written by Dr Charanjit Singh. There's the front page, spine and the back page. I would draw your attention to the companion website, which is an innovation. It's there as well, because you've got the textbook, but you've also got, with the textbook, you've got some useful links to the website for additional materials. It's 160 odd pages long. There's the index right at the back, which sets out some basic information. Each chapter has a little bit of further reading if you want it. There's a summary also with the chapters, the back. You've got a few diagrams. For instance, there's one diagram there. You have quite a few cases. This is an important one, Rush and Tompkins versus the GLC, the Greater London Council. Very well known leading case. You've got quite a large range of useful points there. There's another case. The law of evidence, of course, has a huge amount of case law, but fortunately they've got the balance right here. This is the mission statement from Routledge about why they've produced these beginning series of books. There are a number of them available, all in the spring of sort of summer 2014. You can see them there. Then you've got the main list of contents in some detail. There are 10 topic areas in total, so they're dealing with the very basic areas of evidence like hearsay, characters evidence, confession, similar fact evidence, witness evidence, how the trial actually goes, and so forth. You've then got table of contents there, which includes the cases, a lot of cases, then a few pieces of legislation as well. Then we move on to the preface. Do read the preface, which Dr Singh has set out. Basically his reasons for writing this book and why it will help you. Then have a look at how to use the companion website, which goes with the textbook and is very useful. You've then got, this is a standard structure for chapter 1, you've got the learning outcomes, and then there's an introduction. What is evidence law? Then you get some interesting little diagrams, which does make a bit of help, where the lawyers come into evidence. Then you have key definitions, and then you've got various other things. You've got case analysis immediately of some very important cases, and then you have some on-the-spot questions, which I think are very helpful. It will help you as you go through, a bit of self-testing, and it's a form of activity as well, which they like at the moment. Not that I'm being critical, you see, of activities, but they are there, and it does break it up, because there's nothing worse, and I have to do a lot of it as a barrister. I have to read very, very long, turgid documents. So it is actually nice to break it up from time to time. Now, let's tell you what we think of the book. We've given it a title, an excellent first step to understand what the law of evidence is all about. Now, my wife Elizabeth and I wrote this review, had a talk about the book, and we thought it was a first-class book. So what I said is this. Dr Charanjit Singh reminds us of what Mark Twain once wrote. If you tell the truth, you don't need to remember anything. Some possibly sage advice when dealing with a subject which is compulsory for all who wish to practice as lawyers. Remember, you've got to do evidence if you're going to do the professional qualifications. This, if anything, is a very nice, easy run into it. I and many other people had a lot of trouble with evidence when we first started. It wasn't very well taught, I hasten to add. There were some people who were very good, and then some people who were very bad at teaching evidence. I eventually ended up teaching it myself at Birkbeck, and I began to realise then it was much more difficult to put across, because the basics are there. People watch the television, they think they know how a trial goes and how you adduce evidence. It's not like that in practice at all. Once you've run the cases, as I have, done the cases in court, then tried to explain it, that's when the difficulties come in, because there's a lot of case law, a huge amount of case law in this area, and things are changing all the time. Now, set out in Singh's excellent textbook is another formidable explanation from the Routledge Beginnings series, looking specifically at the law of evidence here, and it's written in easy understandable terms for, as I've said, what can be a difficult area of law. Superficially it may look easy, but it isn't. And with all the Routledge texts, I think this is one of the best primers on the market to start you off, to see how evidence operates in England and Wales. I like Routledge because they are of outstanding value both in terms of content and cost. They're not expensive, and the authors, who are all legal experts, explain substantive law issues in a very readable fashion. So for both tutors, lecturers and learners, a decision on which textbook can be vital, and this is a good starting off point, I think, because Routledge does lead the field in these legal textbooks, in my view. Many of their texts also have these excellent links to the websites, which is a growing trend now, and one that I'm sure will continue. I teach a lot of distance learners, and obviously they don't have the face-to-face tuition, so it's very useful for them, and it helps them with on-the-spot questions and all the other self-testing. So I think it is a great tool. We'd also say the formats used by Routledge are very much part now of the current teaching methods. I think the learning outcomes, what your objectives are, and what you want to have found out about a subject at the end of the chapter is extremely helpful. You've got the summary, you've got the other links at the end, but I think the structure is very much now a mainstream formula, so thank you very much to Routledge for that. Singh uses diagrams, tables and what he calls on-the-spot questions, which I've shown you, to make the subject come alive, and that he does. It's a useful little bit of activity, if you like. So for us, the companion website is also, of course, an innovation. Do look at how to get into it and get used to using it, because I'm sure this is the way teaching is going to go for the next few years, and I think it's very helpful, especially for those who are not in the classroom environment. I'm sure it will assist with engagement in the subject for you. The key definitions and key cases are of particular help to those new to the subject, and the title, in our view, remains ideal as a first introduction to the law of evidence. Now, the law is as stated in September 2013. As I say, there are not a lot of cases, and I think that's probably a good thing. Here we go. This is a trial process itself. You see there's an on-the-spot question. Then you've got the doctrine of res geste or geste. Again, a little bit of Latin. Very unusual now to have Latin, but this is dealing with events, circumstances or states of affairs surrounding the commission of a criminal offence and refreshing a witness's memory. Remember, with evidence, the vast bulk of these books are actually dealing with criminal matters, because that's where the evidence is really quite important. We've got here, for instance, legal and professional litigation privilege. Again, another little area, very important for us as practitioners. Anyway, I'd like to thank Dr. Singh very much indeed for this book. It's a very useful book for anybody starting out. Anybody who wants to be a practitioner will need to have this, because you've got to have a good grounding in procedure and evidence today to get anywhere at all. So thank you to the publishers, the author, and to listening to me, and good luck with your studies. Bye-bye.